When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.
Every citizen has a right and every citizen has an obligation.
That a plea of ultra-virus acquit or convict is very different from the plea of pardon.
Trespass is that act that interferes with the peaceful.
No matter how minute
this right, no matter how minute.
He who comes to equity must come with clean hands. Hello out there, you are welcome to another fresh episode of Justifying Nigeria on ACNN television, reaching you from Abuja. On today's episode, our subject of discussion will be the legal concept of arrest part 2. My name is Anozie Chinomso, your anchor. It remains a statement of facts that the legal concept of arrest cannot be exhausted in one day. And therefore, there is need to properly dissect and x-ray in a perfect understanding its essence and legal importance. In our last episode, we looked at the basis and fundamentals of arrest. In this episode, however, we are going to be looking at the arrest in the context of its legal weight, which sets into motion the legal basis for arraignment. How then can arrest be made? Is there any difference between a summon and arrest? What happens when a person resists or tries to escape from being arrested? Who has capacity in law to arrest and to issue warrant of arrest? Does the retirement, death, removal from office of lost jurisdiction by the warrant issuing authority invalidate a warrant of arrest? Joining me now in the studio to explain all this and more is Barrister Chika Nwagu. Barrister Chika Nwagu is a senior partner at Zat's law firm of number 6 Baku Street, Wusetu, Abuja, and also a member of Unity by here in Abuja. You're welcome to the program, sir.
Thank you very much.
Thank you very much, Counsel. Now we talk about arrest, but you agree with me that our viewers out there, most of them are not lawyers like you. So to the better understanding of our viewers and on points of law, briefly explain what arrest is all about so we can start through that in our discussion.
Okay, thank you very much.
Thank you.
So, arrest simpliciter. Without
please be using kind because what do you mean by simpliciter? That's so that our viewers, most of them are not lawyers. So what do you mean by simpliciter?
Simply put,
you are communicating
within the purview of a layman.
Good.
Is when you legally confine somebody who has probably been subject of a criminal complaint. It can be issued by a judge or a magistrate that someone should be arrested, that is upon receipt of a complaint against such a person, or it can be done when such a crime or suspected crime has been committed before a police officer or before a private person. So basically, arrests can be conducted by both a private citizen and
as you and as I am, anybody can conduct an arrest. That's what we're saying.
Yes, by Section 28 of our Administration of Criminal Justice Act,
okay,
which has been domesticated in most states in the country. A magistrate, okay, justice of the peace, a judge, a police officer, a private citizen
can conduct an
arrest.
So that means as a private citizen, you have the right, as a duties program, to arrest anybody you see committing a crime. That's what it means.
Yes.
Now, Counsel, now we'll talk about this arrest, just mentioned about it. Now, we also hear about summons. You agree with me? There are many people out there that are not lawyers. Then when they hear summons, they hear arrest and all. Is there any difference between summons? First of all, what is a summon? Then what is the different or similarity, as the case may be, between that of arrest and summons?
Okay, thank you very much. Summons, simply put, once again, is a notice that there is a pending criminal or civil suit against an individual. Simply put. Now, there are categories.
Okay.
There's a criminal summons and there are civil summons.
There is criminal summons.
Yes.
And there are.
Yes.
So them is that of civil. There are many of them. That's
Of
what
course.
it means. Okay, please educate our viewers.
Ordinarily, there are different categories of civil suits. It could be a petition, it could be a writ, it could be, as the case, there are petitions, there are galore.
all those things
Exactly,
are
yes.
okay.
But then in the criminal aspect, it is just one. Why? Because our criminal code, our criminal judicial system is linear in that way. But in any event, they both serve the same purpose, to notify an individual that there is a pending criminal or civil suit against you. Now, usually for criminal summons, there has to be a complaint before a judge or a magistrate, who now, exercising his judicial powers, issues a summons in form of an order directing that you, against whom a complaint has been made, appear before so panel, so judge on so date to answer for allegations levied against you.
That's summons.
That is a criminal summons.
So is there any similarity or an otherwise relationship difference
Between summons and
an
arrest?
arrest? Yes.
Okay.
If there's any relationship, you tell us. If there's none, you tell us. Then if there's also difference, you let us know.
Okay.
Yes.
Well, let me do similarities first.
Okay.
The similarity there is that they both require your attendance. They both command your attendance to court.
Okay, but of course, both of them are command, of course.
Both of them are command. They all require your presence. Summons notifies you that your presence is required. Arrests
Still notifies
you that you are needed. But the difference is that in summons, you can decide not to show up. Do you understand? But in arrest, you don't have a choice. You don't have a choice. You must, whether you agree or not, you'll be confined. You will be placed on custody. So that is the difference. One, they're both mandatory orders. They're both mandatory. They must be obeyed. They carry the force of the judicial law. But then, one gives you discretion, a little discretion. But the other one does not afford you any discretion.
Okay, that's
you must come along. If a police officer serves you a summons or a bailiff serves you a summons, he's notifying you that you are required in court. But if the police officer is coming with an arrest warrant, your discretion disappears. You are immediately put behind the truck.
Immediately.
So
all right, now when you are talking about this issue of arrest, who has the capacity in law to arrest? Because I heard you mention police officer. Are there only people that can arrest? Who are the people that can arrest, or categories of people that can arrest?
Well, like I said earlier, Section 24 of the ACJL, the Administration of Criminal Justice Act, by Section 28, provides that a judge can arrest.
That's number one.
Or order for someone to be arrested.
Okay.
A justice of the peace, a magistrate, private
A
person.
justice, that's JP.
Yes.
Okay, well, because I know there's this JP, there's this one, Jerusalem Pilgrim and Justice.
Not that
It's
one.
not that
It's
one.
not that one.
So that's why you call it a justice of peace, not just
Exactly,
JP.
not JP,
Before
yeah.
someone has said I'm a Jerusalem Pilgrim and started arrest, all right. So the justice of peace.
Yes, the justice of the peace.
Okay, and who are that person?
And private individual. Basically, law enforcement in Nigeria can effect an arrest, whether by warrant or without warrant. Exactly. Those are the categories.
These are the categories.
Yes.
Because why I'm asking this question is because of what we have seen happening, especially in the reign of the
But
moment.
mind you, private individuals, for them to arrest,
Okay.
it must be for crimes that happened in their presence.
Okay, you have to distinguish that
Yes.
fact. Okay.
It has to be one that happened in their presence, not one you heard that they stole last week, and then you return from travel and said, okay, let me
it's
get
only
arrested.
the law enforcement agent that can do that.
At any time.
But you and I cannot just say,
You cannot
Mr.
just wake
A,
up.
I just...
You can't get arrested. No, you cannot do that.
Okay.
Yes, that is the prerogative of law enforcement.
Yes, thank you very much. Now, having stated that, Council, this few weeks that have just passed, we heard about, in fact, people are rejoicing the repatriation of Nnamdi Kanu, and all that. But I want to ask a question as a lawyer on points of law. What is your take in legal perspective, that issue of repatriation of Nnamdi Kanu to continue trial? On the ambits of law of definition of arrest, did Nnamdi, was he actually arrested? What is your take generally on that perspective?
Well, that's a very tricky question, and I will tread carefully because of where I come from.
But educate our views on point of law.
Exactly,
Anyway, on
that's what I
point
said,
of
that's
law.
what I want to do.
Exactly.
Nnamdi Kanu, from the information made available to us, he wasn't rearrested in Nigeria. He was rearrested outside the shores and jurisdiction of Nigeria.
Which up till now, none of the Nigerian cities know the country.
We don't know the country because recently Wilfred Mange,
Yes.
the High Commission to
Kenya denied immediately.
British High Commission also issued a denial that he wasn't arrested in their country. So Nigerians do not know where he was arrested.
It's
But
only
we
the
know.
authorities of Nigeria that knew the place.
But we all know that he wasn't arrested within Nigeria. And for that to happen, Nigeria has an Extradition Act, which is now part of our LFM. It was.
We're
promulgated.
going to go on a short break now so that you explain. I don't want to cut you short. When we come back, you educate us on point of law as regards to Nnamdi Kanu's arrest. Please, viewers, do join us again. Hi, you're welcome to The Speaker on ACNN Television, reaching from Abuja. The Speaker is a platform by which we treat some topical issues happening in the polity. On today's segment, we are going to be looking at desirable Nigeria or a miserable Nigeria. My name is Anoze Chinomso. The word desirable is oftentimes referred to something that is worth having, pleasing, and worthy of adoration. It therefore means that once someone or something is desirable, great quality of happiness, joy, and unity with members of a given society is always achievable. On the other hand, miserable is always used when something is deplorable, despicable, pitiable, and misfortunate. When a nation is desirable, the people rejoice. But when it is miserable, the people mourn and suffer. With the kind of pathetic and piteous things happening in Nigeria, I'm persuaded to ask on whether we are living in a desirable Nigeria or a miserable Nigeria. When Kaduna State, that is supposed to be a center of learning, has suddenly become the dwelling palace of bandits and kidnappers, is an example of a miserable Nigeria. When Emir of Kajuru community in Kaduna State was kidnapped and later released, while 13 others are still in captivity, is a perfect example of a miserable Nigeria. The kidnapping of students of Bethel Baptist High School in Kaduna State is a perfect picture of a miserable Nigeria. When bandits are demanding foodstuffs such as bags of rice, bags of beans, and so on, shows how hungry and miserable people can be in a miserable Nigeria. When a governor of a state in Nigeria withdraws his son from school and puts him in another school which he feels that has a better level of security and neglects the cries of his subjects whose children and loved ones are kidnapped, is a clearer pointer to the fact that we are living in a miserable Nigeria. Kaduna State government releasing statistics of 774 persons that are being kidnapped and 222 persons killed in just 3 months affirms my submission that we are dwelling in a miserable Nigeria. In a situation where suspension of 6 lawmakers and shooting of guns seem to be a new way of saying an opening prayer before starting the legislative business in the Imo State House of Assembly, is a clearer picture to the fact that we are living in a miserable Nigeria. The tactful removal of Clause 52 from the proposed Electoral Amendment Bill, which empowers INEC to transmit results electronically, the INEC power to review results if those results were not declared voluntarily, is an obvious reason to believe that we are living in a miserable Nigeria. How can it be that the National Assembly is proposing in the new Electoral Amendment Bill that expenditure campaign for anyone running for the office of the president should be ready to spend 15 billion naira, 5 billion for the office of the governor, 1.5 billion for the Senate, 1 billion for the Federal House of Representatives, and 500 million naira for state houses of assembly. In the economy of Nigeria, that is so poor that an average Nigerian feed below $1 per day. It is now evident to me, even to you, that Nigerian politicians have no conscience at all, and they do not mean well for Nigeria. It appears that we do not have uniformity of our laws in Nigeria anymore. It appears we have laws for North and laws for the South. How can it be that in the North, terrorists are called bandits and government negotiates with them and pay them huge amount of money for their terrorism, while in the South, unarmed freedom fighters are called terrorists and government arrest and even kill them at will? How can it be that in the North, police do not arrest criminals or extort motorists, but in the South, police arrest innocent citizens and extort motorists? How can it be that in the North, Northern youths can kill innocent Southern youths and no one will arrest them, while in the South, Southern youths get arrested for attacking armed Fulani henchmen? How then will people believe in one Nigeria with these ill treatments? That is a jump and wire question for you. All of this can only happen in a miserable Nigeria. When I look at Nigeria of today, with all that are happening, my prayer can only be, into your hands, O Lord, we commit Nigeria. In order to justify Nigeria, I therefore speak, until all of us begin to see ourselves as one and treat one another with love, equity and fairness, and stop all this unnecessary segregation and division, and endeavor to ensure that our collective efforts and ideas are properly harnessed and utilized, begin to condemn and punish evil at all times, no matter whoever that is involved, having a common belief that the betterment of Nigeria is for all, and thus all hands must be on deck in order to build a solid Nigeria with a strong economy. We shall continue to live in a miserable Nigeria instead of a desirable Nigeria. My name is Anoze Chinom, so I just want to speak. Hello, my dear viewers. Glad to know that you are still there. And we are still here in the studio with Barrister Chika Nwago. Counsel, thank you very much.
Thank you very much.
Before we went on a break, you are trying to explain on the issue points of law, how you view this arrest of Nnamdi Kanu. But however, there are some lawyers like you, opinions are divided, that Nnamdi Kanu, actually, you can't call that arrest. Some people call it interception or capturing. But I hear you, I wouldn't know, as a lawyer educator, so that it will not be a contradiction. Based on the context of the laws available, can somebody be arrested in another country? Because I know some lawyers said no, that is not, in fact, the Nigerian government captured or, whatever, they didn't call this arrest. What is your point before you expatiate? So just go ahead from that. Take it
Okay,
from
my
there.
opinion first before the law.
Exactly.
Okay. In my simple legal opinion, Nnamdi Kanu was not rearrested. He was kidnapped. And that is, in plain words, that's what it was. He wasn't rearrested because...
Based on the law,
based on my opinion.
Exactly, as a lawyer, exactly.
On my opinion
Yeah.
as a lawyer. Because
Well,
for there to be arrest,
fine, that's what I want to get.
there has to be procedures to be followed.
Like?
For example, if you are being arrested in Nigeria, the law is clear on what procedure and what methods are to be taken before such arrest can be legal and to be effectual. And they are provided in our ACJL, in our Criminal Procedure Act, from Section 4 of the ACJL down to Section 17, even up to Section 19, provides for arrest and the rights that are supposed to be accorded to a person who is arrested. You understand? But as to the case of Nnamdi Kanu, the situation is quite different, I must say. Nnamdi Kanu has already been arrested previously. He has been arraigned. He is standing trial for offenses that the federal government has raised against him. Bordering on, I think they struck out terrorism, so what was left was a possession of firearms, unlawful society, treasonable felony, which carries a death penalty. But then he was granted bail. 12 bail conditions, which is stringent. And by our laws, such bail conditions are illegal if we are being truthful. Because even recently, the Court of Appeal in the case of Dasuki against the director of the TSS, the court impugned those bail conditions that were imposed on Dasuki. Said that the essence of bail conditions is not to punish the person, because the person is still standing trial. He has that presumption of innocence. He has not been convicted yet. So imposing those bail conditions and making them stringent is against the spirit of the law as regards bail. Now, he fulfilled those bail conditions. I'm talking about Nnamdi Kanu. And now, for some reason, absconded, left the country, which is a clear deviation from his bail
No,
conditions.
you're a balanced lawyer. You're balancing it. That's one.
Because ordinarily,
he shouldn't have John bail.
he shouldn't have John bail. Because the essence of giving him bail, one of the conditions, the major conditions of bail in the first place, is the ability and the capacity of the person to come back and face trial. He was granted bail in 2017. He jumped bail. In 2019, the bail was revoked and a warrant of arrest was issued. Now, ordinarily, by our laws, and by our laws I mean the Extradition Act, now LFN 2004, but of 1965, for a person to be extradited, at least by Section 6 of that same Extradition Act, there must be a competent court order instituted by the Attorney General of the Federation and directed to the consulate of whichever nation Nnamdi Kanu is seen or heard to be taking refuge in. Because by that state, he becomes a criminal fugitive. And by the interpretation section of the Extradition Act, Section 26, a criminal fugitive is one who has a criminal complaint against him, facing trial and absconds, or someone who has been convicted but has not finished serving his sentence. You understand? So Nnamdi Kanu falls under the first leg of what constitutes a criminal fugitive. Do you understand?
Yes.
So now,
But none of these things was happening. None of all these things. You are coming to. You are going somewhere. That's why he said that he was kidnapped.
I gave my opinion in the first place.
Good. Okay. Continue, sir. Continue. This is becoming
now-
interesting.
So now, ordinarily, what the Nigerian government simply should have done was go to a magistrate. As simple as a magistrate.
No, not even a high court
Not
judge,
even a high court judge,
or even a
that's-
Supreme Court justice.
The law is clear. The Extradition Act says magistrate. You don't even need to go to a high court judge. Go to a magistrate as the Attorney General of the Federation. Get an order for the extradition of this man. Serve it on the consulate of the nation you think Nnamdi Kanu is being held or hiding under. And then they will consider it. And by Section 2, if truly Nnamdi Kanu was in Kenya, by Section 2 of the Extradition Act, all Commonwealth nations have an extradition treaty with Nigeria, of which Kenya is a Commonwealth nation.
Of course.
So it would have been a simple
And legal thing.
instead of this Gestapo method of enforcement. Nigerians, ordinarily, we shouldn't be here, but we are here. In any event, I still give my opinion on it. The law as to extradition was not complied with.
So that means you agree with some of your brother lawyers that say Nnamdi Kanu was not arrested at all. In fact, they don't want to hear that issue of that. Maybe because he did not comply with the law, you just cited and explained. They said no. Some people say he's kidnapped. Some people say he was captured. Some people said he was, maybe, but that was that arrest.
And you listen to the interview of the Attorney General on the 28th of June, when asked how this so-called arrest came about, he said it was joint effort of intelligence and security services. As in, which of the security agencies in Nigeria is nameless? They all have names.
And the High Commissioner of Kenya have denied. So that means only them knew the country.
They know the country. And how it was done, how it was packaged. Because I saw the pictures on social media. He was looking like someone that was just brought out of the cargo department. So you see, we have a long way to go. That is not what we call arrest, at least not according to our
laws.
legal system.
Thank you very much, guys. I think you've done justice to that. Now, what happens when one resists or tries to run or escape from arrest? What happens?
Okay, by Section 5 of our Administration of Criminal Justice Act, upon arrest, you can be confined or restrained. But Section 6 says it's not mandatory. Even Section 5 says it's not mandatory. When a person willingly, voluntarily submits himself to be arrested, either by conduct or by words, he should not be handcuffed. But the proviso there is when the person is a danger to himself or when the person attempts to escape arrest, then he should be placed under restraint. So in circumstances where one is seeking to escape arrest or when arrested is seeking to maneuver to jump bail, the law enforcement agents are entitled to confine such a person in such a reasonable manner that escape will be impossible.
Okay, a reasonable man is a matter of circumstance.
It's a matter of circumstance.
Now, Counsel, before we go, we just have a few minutes to go. Now, oftentimes we look at the issue of warrant of arrest, which you have explained that it must be done by people that will judge and must have to also spell out the offense that the alleged offender have committed. Now, suppose there's a retirement of that issuing authority, maybe in this case judge, or death, or the mover of office is no more a judge, or maybe the jurisdiction or the office is out and all that. Does it invalidate that particular warrant of arrest? You understand my question?
I understand your question.
Okay,
I understand your question. Well, like I mentioned earlier, every warrant does not just come on its own. Every warrant has something, a process that precipitates it. Usually a complaint, a criminal complaint. Now, it is before the judge that the complaint was made that warrant of arrest is usually issued. Now, when the issuing authority is no longer in existence, either maybe by transfer, death, retirement, and the rest of them, ordinarily, that warrant of arrest dies with it. And that is the law. Except another warrant of arrest is issued, because a warrant of arrest is an order. And we know that orders of courts bear fruit or receive life from the issuing authority, which is the court. Now, when the court is no longer in existence, when the court is functus officio, when the court is no longer in existence, so also that warrant and other orders made by that court in that matter goes with it.
Okay, unless there's a new one.
Except there's a new one, which can be reactivated by the Attorney General, Office of Attorney General, or the police. Because it is a matter of public policy. It is not a private affair. Meaning if the police deems it relevant or necessary to go and reactivate it, they'll go and reactivate it.
Okay, once it's been reactivated, that particular one,
it comes back again.
Thank you very much. Once a warrant of arrest is being reactivated by the issuing authority that is dead or that is being retired, it can still be valid. Barris, I want to thank you so much for coming. And I know when next time we call you out of your busy schedule, you will find time to oblige us. Thank you so much.
Thank you very much.
An arrest is the fulcrum and the fundamental commencement of any criminal trial. This is because the court does not try a ghost or non-existent person. Therefore, when making arrests, it is important to carry out the necessary and preliminary investigation that will establish your case in court. Suffice it to say here, for the purpose of clarity, that when an offender resides or is found in a state different from the state where a warrant of arrest is issued, the offender can still be arrested, provided that the procedure required by law in such circumstance is complied with. Always remember that you watching and listening to me, has the power to arrest anyone you see committing a crime, because a private person is empowered by law to arrest at that moment. It is a collective duty we all must do in order to ensure that our society is sanitized and devoid of crimes. Therefore, when you see something, say something and do something. This is where we draw the curtain on today's episode of Justify Nigeria. Join us same time, same station on another fresh episode of the program. Until then, this is Anozie Chinom, so wishing you the very best and bye for now. When one is horrible, it means that there is nothing that is objectively good and progressive that will come out of such individual.
If you have been convicted of an offense before and you have been pardoned, and anybody is trying to bring that up against you and calling you a convict, you have the power to sue that person for defamation.
Justice must not only be done, but it must be seen by all to have been manifestly done.